because it's irrelevant. It's going to incorrectly let the jurors think that this was a legitimate citizen's arrest, because we're talking about use of force during an arrest. But that use of force during an arrest by a law enforcement officer is a completely different standard, because a law enforcement officer has three things. Number one, he is in uniform and has a body cam usually these days and a marked patrol car. He is employed, meaning there's something for him to lose or for her to lose if for some reason she violates the use of force policy, namely a salary and a job. And that officer has been trained on the standard operating procedures for that particular police department, has training on that policy, has training in that department's policy of use of force and the consequences for what not following that policy, what those consequences are. None of that applies to any of these defendants. None of them were law enforcement officers. Nobody was employed by a law enforcement agency. So we don't have any of those elements in this case. The reason this would be really highly prejudicial is because it doesn't go to any issue in this case. The state will cite to State versus Copeland, 310 Georgia 345. This was a 2020 case. And in that case, the Georgia Supreme Court held that law enforcement officers who are seeking immunity, basically self-defense in an immunity motion in advance, are subject to the same exact self-defense standard as a private citizen. In other words, you have to be reasonably in fear of receiving serious bodily injury or death before you ever use lethal force. And that force used must have been based on the defendants, whether they're law enforcement or whether they are a private citizen, their reasonable belief that such threat or force is necessary for self-defense. So inserting use of force in all the standards and explaining to the jury at Flexi, this is what we train law enforcement officers, has absolutely nothing to do with this standard from Copeland. I also cite to Kilpatrick versus the state, 308 Georgia 194, also a 2020 case from our Georgia Supreme Court. There they found it was not an abuse of discretion when the trial court refused to allow the expert to testify because it did not believe the expert's testimony about use of force, fight, flight, freeze responses, and human physiology during high stress and life-threatening situations would be helpful to the jury. And the reason is because self-defense is not outside the ken of an average layperson. No one needs to explain self-defense to an average juror. The law is very, very clear that the use of force, the force used, must have been based on the defendant's reasonable belief that such threat or force was necessary to defend himself. Prior training, or even lack of training, has absolutely nothing to do with that reasonable use of force. Therefore, the expert's testimony would be irrelevant under 401. It would be confusing, misleading, and of course highly prejudicial to the state. Because having a use of force expert come in and go, well, I'm law enforcement, I taught at Flexi, I know all these things, I'm going to explain the training these men had in use of force, it actually implies that they were entitled to basically make an arrest and that they were acting somehow in the capacity as law enforcement officers because they'd had some sort of previous training in use of force. Now, the state's not suggesting that if Greg McMichael takes the stand or Travis McMichael takes the stand that they can't talk all about what they knew, when they knew it, and what training they'd had, what year it was, what they'd been taught, how that affected what they were doing to explain their actions to the jury. That's perfectly acceptable. But you can't have an expert come in if they don't take the stand and go, well, my understanding based on some records are they had this training and this is the training they had, because it's not relevant and it's bolstering that particular defendant's position. And the defense's response to this is exactly what we're talking about. The problem with the defense's response here, Judge, is they've conflated objective and subjective. They first assert that the defendant's belief in the necessity of using force must be reasonable. The actions must have been motivated by the fears of a reasonable man. A reasonable man is also a reasonable woman. So what we need to do is look at this from the perspective of, and I'm just going to randomly pick somebody, a 50-year-old Asian female. Okay? So what's reasonable for her has to also be reasonable for them. And if she's never had use of force training, It's still the standard of reasonableness. The defendants, however, here conflate it by then saying jurors are permitted to consider how a reasonable person in defendant's particular circumstances would react. That's subjective. That's a subjective standard. Now, they're allowed to go ahead and explain this in order to go ahead, the defendants can take the stand and explain this and go, well, this is why it was reasonable for me personally, but to have an expert take the stand in order to bolster, without them testifying, it was reasonable, or even if they did testify, to say, oh yes, this was reasonable because they had this training, we're now on a subjective standard. The defense say they're basically saying the jury will hear evidence regarding Mr. McMichael's training and experience while he was in the United States Coast Guard. Not sure how that's going to come in except through Travis McMichael, because such training and experience is not relevant at all for the reasonable man standard. He can testify about his training, but for him to be held to the reasonable man standard, it's anybody. It is against this background that the defense intends to call a retired federal law enforcement officer to explain the concepts that Mr. McMichael knew, relied on, and employed on February 23rd. That's strictly bolstering what Mr. McMichael would testify to. Travis McMichael takes the stand, he can talk all about what he knew in his training. And the problem is, if he gets up on the stand and says, well, I got trained in use of force, gets off the stand, then this expert gets up and goes, well, here's what he was trained, and then explains it in minute detail. That's bolstering, because it's not saying what Travis McMichael had in his head specifically. He's the only one who can talk about that. It's now explaining back in the day, however many years ago, he got some training, and this is what the training was. I'm going to explain it to the jury. The defense goes on to say, use of force continuum, perception reaction time, de-escalation techniques, restraints on the use of deadly force, weapon retention techniques, the ability of an unarmed person to inflict serious bodily injury and to continue to inflict injury even when injured. And then we have the determination of probable cause. Well, you're going to explain the law to this jury. And probable cause is a law enforcement standard, not a standard for the defendants in this case. And the reason that the state has serious concerns about the determination of probable cause is that's a jury charge. That's something that's going to be explained from the court, not from an expert in use of force. Obviously, the state, if the defendants want to get up there and basically say, oh yeah, I determined I had probable cause, then that's an avenue that they can do, and the state will cross-examine them on that. The defense then goes on to say expert testimony on issues to be decided by the jury, even the ultimate issue, is admissible where the expert's conclusion is one of which the jurors would not ordinarily be able to draw from themselves. They concede that experts are only required when it's a conclusion that is beyond the ken of the average layman. Jurors are asked to determine the reasonableness of self-defense claims all the time without expert testimony. This case is absolutely no different. It's not outside the ken of the average layperson. Basically, at this point, the defense claims that they want this expert to educate the jury on the aforementioned concepts at issue in this case. Concepts at issue. None of these concepts are at issue in this case. Travis McMichael takes a stand and talks about his training. He gets cross-examined about his training. Those concepts, I guess, are use of force continuum, perception, reaction, weapon retention techniques. Travis McMichael can talk all day long about what he knew and was in his head at the time, but none of those concepts are in dispute. He's just subject to cross-examination. They want to educate the jury on concepts taught at Flexi. Well, that's not relevant. And concepts that inform Mr. McMichael's decision-making. There's no need to have an expert educate the jury about what was in Mr. McMichael's head. Mr. McMichael's the one who needs to do that. And then how Mr. McMichael's actions were consistent with his training. In other words, they want this expert to get up here and go, yeah, everything he did was okay. He's allowed to go ahead and do this because he was trained. That would bolster this, and it's not outside the ken of the average layperson to determine whether what Travis McMichael did was reasonable or not reasonable under the circumstances. This is, of course, very troubling. Mr. McMichael's expert will educate the jury on what Travis McMichael was taught about the guardrails imposed on law enforcement officers by the Fourth Amendment. Once again, no one here was a law enforcement officer. The expert's testimony about Travis McMichael's implementation of his law enforcement training. Well, he can go ahead and discuss that, but once again, this bolsters this concept of citizen's arrest in the minds of the jurors by implying that he was acting as a law enforcement officer at this particular time, when he was in no way hired, retained, acting in the capacity as any sort of law enforcement officer. As we all know, he was employed at Metzen Marine at the time, not with any law enforcement agency. And they then claim it will assist the jury to assess whether Mr. McMichael's actions and beliefs were objectively reasonable, not outside the ken of the average layperson. And this idea that an expert should come in here to bolster his subjective reasonableness, the state objects to that. Your Honor, in addition, I believe I emailed your office and provided the defense with the state, Cantrell versus the state. If you do not have a copy, I have an extra one right here. Thank you.
When did you email that?
I emailed it to you guys about 3 weeks ago. So I apologize, I only gave you 2 copies. It's Cantrell versus the state. It is from August 12th of 2021, so it's A21 A0773. It's a Court of Appeals decision. The defendant, Cantrell, had been convicted of 3 counts of child molestation and 1 count of aggravated sexual battery. So the underlying facts are different, but Cantrell contended that the trial court erred in restricting his cross-examination of the forensic interviewer. And basically, the court said the permissible scope of cross-examination is committed to the sound discretion of the trial court. Georgia law forbids expert opinion testimony that implicitly goes to the ultimate issue to be decided by the jury when such issue is not beyond the ken of the average juror. So in this particular case, what we had is we had a teenage girl who didn't want to live with mom and dad anymore because she was being, I think it was mom and stepdad, because stepdad was molesting her and she wanted out. The defense's argument was she just wanted to be free of mom and stepdad. And they wanted this expert to be cross-examined on this whole issue of, well, isn't it possible that she's just an ornery teenager who didn't want to live with her mom and stepdad? And that is not a concept outside the ken of the average layperson, that teenagers might not like mom and dad, and that's what the Court of Appeals held. An expert may not testify as to his opinion as to the existence or not of a fact unless the inference to be drawn from the facts and evidence is beyond the ken of the jurors. That is, unless the jurors, for want of specialized knowledge, skill, or experience, are incapable of drawing from facts and evidence such inference for themselves. Self-defense is totally within the jurors' ability to draw inferences from the facts and evidence. Do it all the time. Jurors do not need specialized knowledge. They don't need skill or experience to keep them from drawing a conclusion from the facts in this case as to whether Travis McMichael, Greg McMichael, and defendant Bryan were acting in the capacity of self-defense. Where the path from evidence to conclusion is not shrouded in the mystery of professional skill or knowledge. That sort of special skill and knowledge is when you have a firearms examiner, when you have a medical examiner, where you put up that kind of specialized skill that the jurors are not going to have. The conclusion determines the ultimate issue of fact in a case. The jury must make the journey from evidence to conclusion without the aid of expert testimony. So there's absolutely no reason for expert testimony on use of force when no one was a law enforcement officer here. They then cited to the Harris case, and they noted here that the jury heard ample testimony from the victim and her aunt, and they were subject to cross-examination. In this case, if Travis McMichael takes the stand, the jury's going to hear from him. They're going to be able to judge his reasonableness in these actions if he's claiming self-defense. And once they hear from him and or maybe his father, Greg McMichael, they will be able to make that decision themselves. The jurors will, because it's not outside the ken of the average layperson. This is why we are motioning based on 401, it's not relevant, and certainly 403, it is far more confusing and prejudicial than it is probative on the issue of Travis McMichael's reasonableness and his claim that he was acting in self-defense. Thank you, Your Honor.
Mr. Rubin.
Thank you.
Your Honor, I do want to be clear about a couple things that the state seems to be under the misimpression of. Number one, we don't intend to offer an expert on the ultimate issue in the case. Did Travis McMichael reasonably believe that deadly force was necessary on February 23rd, 2020? Nor do we intend to offer an expert opinion on whether he properly believed that citizen's arrest was appropriate in detaining Mr. Arbery for the police on that day. But this case is unlike other self-defense cases, and that's why we do believe it's proper to use a use of force expert in this case. It's different because although Travis McMichael was not post-certified, didn't have arrest powers, he'd been trained for 10 years on the very law enforcement techniques that all police officers get. It's not standard operating procedures of a particular police department. These are the national standards set by the U.S. Supreme Court in Tennessee v. Garner and other cases on use of force decision-making and when it's appropriate or how it's appropriate in particular situations. So these are standards under the Fourth Amendment search and seizure law that are taught at every police department, both state, local, and federal. Travis McMichael, and I agree with the state on some points. Believe it or not.
Just marking the time.
Yeah.
Before the first day.
You may not hear this again. The use of force expert has to be informed about the facts of the case. The use of force expert has to be informed of what Travis McMichael's training was in the United States Coast Guard. So we know, and the state knows exactly how Mr. McMichael was trained, because we all have his records. We all have the lesson plans. We all have the transcripts from Mr. McMichael's tenure in the Coast Guard. That is training and experience, both hands-on training and classroom training, that every federal law enforcement officer goes through. That is also the same training that state officers go through either at their local police academies or, as you heard through voir dire, some go to FLETC to get this training. There's nothing unique about it in terms of police officers. But it does inform the actions of Travis McMichael on February 23rd. You don't just throw away your 10 years of training when you become a private citizen, especially when that training is drilled into the Coast Guardsmen or other agents repeatedly so that it becomes muscle memory. That's the whole point of it. You're not supposed to be thinking out there. You're supposed to be acting on muscle memory. That's how you save your own life and the lives of others. Travis McMichael's training and the video, and Travis McMichael even testifying, would inform an expert on what he did, what he was thinking at the time, what he understood the facts to be, and how he implemented his training on a particular day. Now, this expert's not going to testify that Travis McMichael acted reasonably on February 23rd under the self-defense statute, but it is proper to use an expert to corroborate the information the jury would receive from both the video, where they can see actions, and Travis McMichael's testimony. The state charged, for instance, Travis McMichael with aggravated assault. And they're going to argue that the act of pointing the shotgun as Ahmaud Arbery is rushing him was a crime. I would anticipate the expert to educate the jury on when it is proper to show a weapon, when it is proper to point a weapon, not for the purpose of hurting someone or killing someone, but for the purpose of de-escalating the threat or the violence at issue. The Georgia courts in Bracewell versus State, 2000 case, 243 Georgia Appeals 792, and Dasher v. State, 146 Georgia Appeals 118, a 1978 case, have both held that the jurors are permitted to consider the defendant's particular circumstances in their determination of whether he acted objectively reasonable. These are the factors the jury has to consider. The concepts that an expert would testify to that are the same concepts that Travis was trained with or trained on are outside the ken of the average layperson. No one outside of law enforcement understands de-escalation techniques the way it is taught. No one understands the use of force continuum that police officers have to think through and are trained on how to implement. No average person understands the ability of an unarmed person, which we've heard of repeatedly in this case, the unarmed person's ability to inflict serious bodily injury on an armed person, whether it's a police officer or a citizen. And at that point, Your Honor, it doesn't really matter whether that person is post-certified or just a citizen. They both have the right to use deadly force if they reasonably believe that they are in danger of death or serious bodily injury. OCGA section 24-7-707 says, in all criminal proceedings, the opinions of experts on any question of science, skill, trade, or like questions shall always be admissible. Again, assuming they're beyond the ability of the jurors to draw those, to understand those facts for themselves. And I would say in this case, given the amount of training law enforcement officers receive, the years of training and the continuing training year after year that they receive, shows the court in and of itself that these are concepts and scenarios that are beyond the understanding of the average layperson. I agree that we would have to lay the proper foundation. This expert can't just come in and look at Travis's training records and testify to what Travis understood or what Travis knew to be true, but that's not what we're doing in this case. This expert, who taught at FLETC for years, continues to teach. And it's not Joe Key, by the way, it's Rick Register. It's a different person who's also on the witness list. Former ATF agent who specialized in teaching use of force decision-making, has both met with Travis McMichael, has reviewed the evidence in this case, and has reviewed the training records of Mr. McMichael. Assuming we lay a proper foundation, which we understand, his testimony on the proper use of force in various scenarios, including the ones at issue in this case, would be admissible. If the court has any questions, I'm happy to answer those.
I have a moment to confer with counsel.
Mr. Goff.
Your Honor, it appears that Ms. Donikowski and I are actually in agreement. We might want to write that one down too, in the sense that I think we agree that the rules of force in the context of an arrest are in fact identical, whether the individual is a policeman, a bail bondsman, or a private citizen. And I think that informs the discussion here. I'm surprised, and the reason I specifically wanted to address this, aside from the fact that the court's charge in this case and these motions affect Mr. Bryan, is it seems to me that the testimony proffered by the McMichael defense is relevant because of the state's decision to indict these defendants on malice murder. Now, if the state were simply pursuing an aggravated assault claim or even a felony murder claim, that would be one thing. I think the McMichael defense is correct even on those, but with malice murder, there's no question that this testimony would be admissible. The question with malice murder is the mental state, and whether or not the jury finds that Mr. McMichael can justify an aggravated assault by a misapplication, what the state contends is a misapplication of use of force, it seems to me that in explaining Travis McMichael's mental state and why he did what he did, because why he did what he did becomes the issue on a malice murder charge. He may have been mistaken. He might be guilty of aggravated assault. He could be guilty of felony murder, but as long as there's a malice murder count in this case, then why Travis McMichael does the things he does are incredibly important. And since my client is charged as a party to a crime in that murder, we certainly have a dog in this fight. The training that he received is certainly relevant to a jury's determination of whether he acted with malice. In other words, it gets to his credibility. Now, if Travis McMichael testifies and he explains what he did and the state doesn't contest it, if they don't challenge it, if they don't go after Travis McMichael's credibility when he tells the jury this is why he did what he did, then that's one thing. But taking a wild leap here and assuming that the state plans to challenge on cross-examination the credibility of Travis McMichael when he gives the reasons why he did what he did, then at that point, that testimony is going to be relevant and it's going to be highly probative on the issue of malice. Your Honor, I'd also note, interestingly, we do disagree. The state just told you that probable cause, and if I got this wrong, someone will correct me, that probable cause is not she said probable cause is a law enforcement standard. It is not a law enforcement standard. Probable cause is the same whether it's a police officer making an arrest, a bail bondsman making an arrest, or a private citizen making an arrest. She's got that completely wrong, and that informs the whole argument here. The probable cause standard is the same. The state wants to make a big deal about talking about objective versus subjective, and that's always a very interesting conversation. The state also contends for the last 18 months that what's in the mind of Ahmaud Arbery doesn't matter. All that matters is what's in the mind of the defendants. Well, when you're looking at it from the defendant's perspective, you might as well put badges and guns and mark police cars for all of them, because from their perspective, when they're trying to conduct an arrest, they're looking at it from that perspective. And the state's whole point for 18 months is what Ahmaud Arbery sees isn't relevant. What's in his mind isn't relevant. It's only what's in the minds of these defendants. So again, I think the state is unintentionally proving Mr. Rubin's point. Your Honor, and again, in closing, I'm not suggesting that the training that Travis McMichael received or didn't receive ultimately makes anything he did that day okay. But it is relevant for a jury to determine malice in this case. And for that reason, if for none of the other reasons offered by Mr. Rubin, that expert testimony should be admitted. Unless the state is willing to concede, and that would be nice to know before opening statements, unless the state is willing to concede the credibility of Travis McMichael on that subject. Because if they're going to challenge it, then it's fair game, and we should all be allowed to talk about it in opening statement. Thank you.
State's motion, any final word?
Yes, Judge. Your Honor, we were handed two names, Charles Key and Rick Register. This is the first time I'm hearing that the person going to be testifying is Rick Register. I have no CV for Mr. Register. I've gone to his website where he offers training classes and then lists, I've had this many years of experience, but I have no way to determine whether he's ever testified before, what cases he's testified in before.
That's a different issue, Judge. That's not on the admissibility of it. They can voir dire him. There's no obligation for me to provide a CV or anything, and I'm happy to, but that's not a different issue.
I'd kind of like to do this to keep everybody from popping up. Let's let everybody finish their thoughts, finish their arguments. If there's a response to it, happy to hear it.
Thank you, Judge. So, back again, I have no CV, wasn't provided that in discovery, was not provided with any report. According to Mr. Rubin, Rick Registered spoken with Travis McMichael. I believe the state's now entitled to those statements. If he's going to base his opinion and you allow this in, then at that point the state is going to want to know exactly what it is that Travis McMichael said to this expert in order to make his determination of whatever he's going to say. Now this, of course, is if you allow it in, because he said he's talked with Travis, he's reviewed the evidence in this case, and he's reviewed the training records, and he's now going to render some opinion. So those are just the two issues the state has. If this is allowed in, need the CV. If this is allowed in, Mr. Register did not return my phone call when I called him. Mr. Key did. And to know exactly what is going to be in his testimony. Right now, I have no report or any analysis or any statements from Travis to Mr. Register upon which he's basing his opinion. So those are some of the issues the state has with that. And defense counsel brought those up, so I wanted to bring it to the attention of the court. Once again, we're back to bolstering. As Mr. Goff just argued, malice murder, an abandoned and malignant heart. Malice can be formed in an instant. So the state's not contending there's a misapplication of any use of force. The state's contending what the law is that this was unreasonable to pull out a shotgun and start pointing it at somebody who is not a threat at all, but was simply running while being chased by Mr. Bryan in his truck toward a man holding a shotgun. And then he tried to avoid that man. That's what Mr. Arbery did. So this whole idea that we're claiming it's a misapplication of use of force, we're not even talking about use of force. Those are not our words. Those are their words. Why Travis did what Travis did, Travis can take the stand and explain that. And Mr. Goff just made the state's point. They need this expert to bolster his credibility. That's exactly what they're doing here. This is bolstering. Travis McMichael can get up and talk about his training. He can talk about what was in his mind. He can talk about what he was thinking. But then to have an expert come in and go, yes, this is what he was thinking. This is what he was thinking. And let me explain to you how 10 plus years ago or whenever it was, he got some of this training and this is what he was trained on. I didn't train him on it, but this is what we train people on so that the jury understands what he was trained on. Maybe they do, maybe they don't. But Travis McMichael should be able to explain his training. Because here's the other problem, Judge. Memories fade. And while the defense wants to talk about muscle memory and he was acting in the capacity as law enforcement in their minds, well, they can explain that. But the problem is if Travis McMichael takes the stand and says, I was doing A, B, and C, and the Rick Register gets up there and goes, well, he was trained to do A, B, C, D, E, F, G, and H. Well, there's all these things that Travis McMichael didn't testify he did, and now we have Rick Register going, but he was trained in all these extra special other things that Travis McMichael never said that he knew about. And, of course, it begs the question as to the preparation of Travis McMichael for his testimony by an expert in use of force. So, Your Honor, once again, no one here was acting as a law enforcement officer. If they want to claim in their minds they were acting as law enforcement officers, they can take the stand and explain that. The use of force expert under 403 is far more confusing and prejudicial than it is probative on the issue in this case, because Copeland says so. Law enforcement officers are subject to the exact same standard. I mean, this is 2020, the Supreme Court of Georgia. Law enforcement officers are subject to the exact same standard as regular citizens. 50-year-old Asian woman who takes the stand and says, I was acting in self-defense and this is why, her reasonableness is analyzed under the exact same standards by those jurors as someone who comes in here and says, well, I've had law enforcement training and this is why I did what I did and this is why I was acting. An expert to bolster his credibility and an expert to explain his behavior, all it does is bolster the idea that this was a legitimate citizen's arrest, which is, by the way, the state has to prove it wasn't beyond a reasonable doubt. And so the state is very concerned about this, and we ask you to prevent the defense, to grant the motion in limine, to keep an expert in use of force to come in here simply to bolster his credibility and to make it seem as if he was acting as a law enforcement officer. Thank you, Judge.
Can I make one or two points?
Very,
Very small points.
small points.
It's interesting that the state says that a law enforcement officer stands in the same shoes as a private citizen, because that's exactly true. And the jury's entitled to know, just as they would if a law enforcement officer was on trial, what training and experience that person, whether they're an Asian woman who has no training, or someone who spent 10 years in the United States Coast Guard who has extensive training in law enforcement techniques. The argument is kind of all over the place for the state. Memories fade. Travis McMichael might not remember his training. Those are all questions for Travis McMichael if he testifies. Those are questions for the expert if he testifies. Those are cross-examination questions. What the state calls bolstering is actually corroboration. Travis McMichael, if he testifies, and testifies to what he was taught in the Coast Guard, can be believed or disbelieved by the jury. But a FLETC teacher who teaches the same exact things and who has reviewed Travis's records and reviewed the video and spoken to Travis McMichael can corroborate the concepts, not what was in Travis McMichael's mind, but the concepts that are taught to everybody who goes through the training that Travis McMichael had. It's not bolstering, it's corroboration. We're entitled to corroborate the testimony of our witnesses through expert testimony. Thank you, Your Honor.
I'll tell you how I normally do it. It's the move-ant, response, and then a rebuttal. So just to make sure the day doesn't expand to 7 to 8 o'clock tonight, I try to keep to that, but
And Your Honor, given the extra travel distance from my seat to the podium, may I speak from here?
yeah, I can hear you just fine as long as everybody can hear you.
Your Honor, I have 2 points. One is, and I would suggest the court should be offended by the suggestion made, but not personally, as a judicial officer, that the state's burden in this case should somehow change the rules of evidence. Is the state really trying to suggest that the ends justify the means? That because the state has a need that the rules of evidence change? That's not the way I was taught. The state has to live with the rules of evidence as they are. And my second point is, echoing Mr. Rubin, We do this in all kinds of areas of law. This suggestion by the state that there's something unusual or remarkable here about this motion, I think the court should find troubling. When you challenge the credibility of a witness, you open doors. It's not bolstering, it's corroboration. And that's exactly what the state just cites a child molestation case. We deal with these issues in sex cases, sex offense cases, and child molestation all the time. You do this, you do that, you open doors. And again, the state didn't even respond, and I think before the court goes any further, the state needs to put the court needs to put the state on the spot. Do they intend to challenge the credibility of Travis McMichael if he's going to get up there and testify that he acted the way he did based on his training, and whether right or wrong that he didn't have any malice? Is the state, are they conceding they're not going to challenge his credibility? Because if they'll acknowledge that they are, then this conversation becomes real short and real simple for the court.
All right. This motion was filed back on August 25th with the defense responding October 17th with the additional supplemental information that was provided by the state. Considering the record, considering the arguments of counsel, the court is granting the motion in limine to exclude the use of force experts. There's going to be a written order that will provide more detail on the court's ruling, but generally relying upon Kilpatrick, and actually Cantrell, I guess, is more recent than Kilpatrick, but talks about the same things, where jurors can take the same elements and constituent factors which guide the expert to his conclusions, and from them alone make an equally intelligent judgment of their own, then expert opinion testimony is not admissible. That's Kilpatrick, which again is consistent, I think, with Cantrell. Here we're discussing the objective standard that the jury is going to be using in order to evaluate, it sounds like, the defendant's actions, which are on video and evidence will be presented on. At the time that the defendants were acting, they were not specifically acting as a law enforcement officer. They were private citizens who were acting, as I understand the defense will be, a citizen's arrest. The Kilpatrick was a case, I've got it down here in my notes, where the trial court, there was a finding the trial court did not err in excluding a use of force expert's testimony on grounds it would not be helpful for the jury in determining whether there was a justification in shooting. There's also Mosby versus the state. Let's see. 296 Southeast 2nd, 277. The Georgia Supreme Court has also previously held that an average juror generally can determine without the aid of an expert whether conduct allegedly taken by an individual in self-defense was necessary to protect against death or great bodily harm. It's also Perry v. State, 295 Georgia App 264, that cites Weems versus State, which is a Supreme Court case from 1997, 268 Georgia 142. And again, as was said by most, law enforcement officers are held to the same self-defense standards as private citizens, and that gets into State versus Copeland and Kidd versus Coates. All those sites will be available in the court's written order. I do also point out that there's additional support from other jurisdictions, again, obviously not necessarily holding the weight of precedent in this court. Under more similar circumstances, there's some federal cases, Hart v. Howard, use of force expert excluded, where neither party was acting as a law enforcement officer. The altercation was on video, and the expert's testimony would not be helpful to the jury. There's also one out of, the Northern District of Florida, where trial counsel was not ineffective for failing to call a use of force expert under similar circumstances. There's one out of Maryland, use of force expert not allowed to testify to police officer appellant's use of force as a civilian, because whether a civilian used reasonable force is an issue that the jury can decide without the aid of expert testimony. All of that will be contained in the court's order. Next motion, 4.69 is actually the motion regarding the restriction on extrajudicial statements. That has already been addressed. The next one in line, 469, was extrajudicial statements. That's already been addressed. 470 is the state's motion in limine as to THC.
Thank you, Judge. So state's motion in limine as to THC 4.70. The first thing I'd like to tell the court is that the state is not going to tender into evidence either the blood alcohol content via Amanda Cook of Mr. Ahmaud Arbery. It was negative. He had no alcohol in his system, but we are not going to put that evidence up. Just like we are not going to put up any evidence of any drug tests on Mr. Arbery. The drug tests all came back negative the very first time that the GBI did their baseline test for cocaine, amphetamines, THC, everything. It was only when Agent Dial requested a screening of Mr. Arbery's blood to see if he had any prescription medications in it that a minute amount of THC was discovered in his blood. And I apologize. It would be Jim Gordon who would do the BAC, but we're not going to put up his blood alcohol content. So having stated that that's the state's intent, we are not going to discuss what was in Mr. Arbery's system, what wasn't in Mr. Arbery's system. That's not going to be part of the state's case in chief. We learned from speaking with the defense that they did wish to put in his THC, so we filed a motion in limine to go ahead and keep that out, given it was such a minute amount. And when we spoke with Miss Amanda Cook, she said, listen,
There's a couple toxicology reports, so the state's not using any of the toxicology reports?
none of the toxicology reports, none of them. Not going to put any of it in. They were all negative up until we came up with this minute amount of THC. So we went ahead and filed this motion in limine to keep out this, because when we spoke with Miss Amanda Cook, who is the person who ran the toxicology and discovered the THC, she indicated to us that she couldn't tell us anything about how it affected the victim. I mean, it's THC, part of what's in marijuana. She had no way to determine how it affected Mr. Arbery, what was going to happen with Mr. Arbery if he smoked it, how long ago he smoked it, why it was in his system, when he smoked it. She certainly couldn't tell the quality or quantity of what it was, given, as we all know, marijuana now has marketing value. This one will make you mellow. This one will make you feel this way. She couldn't tell us anything about it. And so the state feels it's not relevant, and we were not going to put it in. In response to this, the defense then filed on October 11th a response to the state's motion. And for the record, the state filed its motion in limine on October 4th of 2021 to limit evidence of the THC in Mr. Arbery's system. October 11th, the defendants filed their response. Their response is that they are going to want to put up an expert, and their expert is the same expert that they were going to put up to go into his mental health. And they basically, with their response, went right back down the rabbit hole of, she can come in and she can say what this minute amount of THC did to Mr. Arbery, because she's also going to testify then to the schizoaffective disorder and all of his mental health records, and then she's going to base that opinion and diagnosis was correct because she's looked at all of his other acts. So now we're backdooring, hey, he had a minute amount of THC in his system, and here's our expert to explain what effect that had on Mr. Arbery, and our expert's now going to go into a 2018 diagnosis. We're going to go into her supporting that diagnosis with all of his other acts, and that's exactly what they have said in their motion, that's exactly where they're going. We, of course, had no idea they were going to proffer and want this woman to then testify to everything that this court has already excluded and written extensive orders on. The state, of course, cites back to the hearings from May 12th and 13th of this year. And we have, of course, the court's ruling from October 1st of this year on the order on the admission of the victim's mental health records. So, Your Honor, we ask that the THC, because it's such a small amount, be kept out. Once again, they had no idea who Mr. Arbery was. He was a complete stranger. The idea that their expert's going to be able to come in here and put all of that evidence in when the court has already ruled all of it out is just a backdoor way to get that evidence in that the court has already ruled as inadmissible. And we ask that it be excluded, and we are not going to go ahead and proffer it or put up any of the toxicology reports from Mr. Arbery. Thank you, Judge.
Your Honor, before I begin, could I inquire whether the state did share with us that they intended originally to put up the absence of alcohol in the system because alcohol in the system could make somebody combative, and so it was their original intent, and they've obviously changed that, what I hear them saying now, but it was their original intent to introduce the absence of alcohol in Mr. Arbery's system at the time of the shooting to demonstrate to the jury that he didn't have alcohol, which could make him combative.
The answer to that question is no. The state had put I'll back up for a second. The person who originally did the BAC analysis is on maternity leave. So the state went ahead and said, well, will you guys stipulate to this fact? And we did it without really thinking it through. Totally admitted, hey, my witness is unavailable. Will you guys stipulate to this? This is how we can put it in. Will you, meaning you guys, the defense attorneys, stipulate to the fact that his BAC was negative? And we were doing it out of transparency. This is our case. We just want to put this in, being transparent. We then went ahead and found Jim Gordon, the peer reviewer, and we served them with that. And then once the THC thing came to our attention, and I apologize, I thought I had told y'all, meaning the defense attorneys, that we had then no intention of putting any of this in, because once we thought about it, and your ruling came out on October 1st about his mental health, none of that became relevant as far as BAC or what was in his system. So we changed it, especially when the defense withdrew their consent to that stipulation. We basically backpedaled, thought about it, and filed this particular motion. So I just want the court to be clear. I hate to admit it, but it was a little, hey, we're being transparent. Let's thoughtlessly put this up. Will you guys agree to it without thinking through the implications of it? Once we got your ruling and talked to the defense, that's why we've withdrawn that evidence. We find it not to be relevant in line with the court's ruling, and we're not going to tender any evidence of the BAC and or the drugs.
I guess my question is that the state informed the defense that they were going to put up the evidence of no blood alcohol because the jury needed to understand there was no alcohol, because the jury could think alcohol, because of the aggressiveness equivalent, that alcohol causes aggression, there's no alcohol, so there was no aggression. And I think that the state needs to admit that to the court, because that was a conversation that we had, that the state recognizes that alcohol could cause aggression, which would make the issue relevant to a jury, but since there is no alcohol, then that was why they wanted to put that into evidence.
Well, let's talk about what the evidence, we're dealing with motions in limine, and so I'm just focused on evidence that is being proposed and what to do if there is anything to do pre-trial.
Okay, I think what's important here, Your Honor, is that the state has shared with the defense that they recognize the relevance of substances in the body.
Objection.
What's the
I
objection?
appreciate this is an objection. I appreciate Mr. Chetwood speaking for the state, but that's not at all what the state is saying. So I want it on the record, while he's speaking for me, that's not what the state intends at all.
Well, that's why I was inquiring. So let me explain to you why I'm saying what I'm saying, Your Honor. In a conversation with Miss Olivier, the state recognized to the defense that substance in the alleged victim's body at the time of the shooting in the case could go to the potential aggression of the alleged victim at the time of conflict. And their goal was to put into evidence that there was no blood alcohol so that the jury wasn't wondering about it, and to solidify in the mind of the juror that there was no alcohol in Mr. Arbery's system at the time of confrontation, because the jury could think alcohol makes people aggressive, so it would be good for them to know there was no alcohol in the system. I want the court to understand that the state has acknowledged the point I'm about to make, and I think it's important for transparency purposes. That being stated, Your Honor, what we know here is that at the time of the conflict in this case, Mr. Arbery had THC in his system. Now, that is a chemical substance that causes behavior. There are a line of cases that go directly to this issue where the defense can establish a causal connection between that chemical substance in the system of the alleged victim and its potential to cause aggression, to cause confrontational behavior, and to cause combative behavior. That's the beginning. Now, not only do we have evidence that Mr. Arbery had THC in his system at the time of the shooting, the autopsy in this case also confirms that he had what the medical examiner calls anthracotic pigment in his lungs, which is associated with extensive, regular smoking of large amounts of marijuana. The toxicologist also confirmed that the THC in the system also corroborates frequent use of marijuana. So there's no mystery anymore around Mr. Arbery's use of marijuana and that he had it in his system at the time of the shooting. Now, the cases that support the admissibility of this type of evidence go straight to really the ultimate question. Is there any connection? And the language that we find in these cases is the presence of this system in the body could cause aggression, could produce strange behavior, potential behavior at the time of the conflict. Those cases, the McWilliams case, which is a Georgia Supreme Court case, 280 Georgia 724, 2006, the court in that murder case excluded the ME who came in a pretrial hearing and said, you know, I've studied the literature on this issue about cocaine metabolites, and in that case also involved alcohol. Didn't know the issue prior to reading literature on it, but studied the literature and found that those substances could cause aggression, combative behavior. The Robinson versus State case, 272 Georgia 131, talks about that causal connection. Gill versus the State, 296 Georgia Supreme Court 351, 2014. Those cases stand for, does the alleged victim have this compound in his system at the time of the fatal encounter, at the time of the homicide? Now, what we know is that he does, but what's the causal connection? Ultimately, Your Honor, we have learned through our psychiatrist that Mr. Arbery has a diagnosis of schizoaffective disorder. I understand the court has ruled this out currently. But schizoaffective disorder, that diagnosis by Gateway, the same institution that this court, not Your Honor, but Glenn County turns to time and time again for diagnosis of people in the criminal justice system, diagnosed Mr. Arbery with schizoaffective disorder late in 2018, early 2019. Our expert has reviewed more information than that expert at Gateway had and concludes that that is an accurate diagnosis, and understands through literature and through her experience, this is Dr. Kelly Kaufman, that an individual specifically with schizoaffective disorder who uses THC has a higher incidence of aggression, that THC in particular, used by an individual with schizoaffective disorder, exhibits aggression. It's documented in the literature, it's understood in the community, and understood by our expert. So, the question for the court then becomes, does he have the compound in his system? Yes. Is there corroborating evidence that he has chronic use, excessive use of THC? Yes. Is it in his system at the time of the homicide, as Robinson stated? Is it in his system at the time of the fatal encounter, as Gill has stated? Is it in his system at the time of the shooting in McWilliams? Yes, it is. Now the question becomes, could it cause potentially aggressive behavior, combative behavior, confrontational behavior? Yes. The expert says yes. Now, the state can cross-examine the expert. The state can say, you don't really know. That's weight. But it is reversible error, as McWilliams has held. New trial to not allow this evidence to come in. Thank you, Your Honor.
Final word from the state.
Yes, Judge. Unfortunately, I'm unprepared to rebut Mr. Shepard's assertion that McWilliams holds that it's reversible error not to let any of this in, because we heard a lot of, could it potentially do this? And potential behavior at the time of conflict. And is there a connection between a minute amount of marijuana that could cause aggression? And we're right back down the rabbit hole that this court has already been down with the mental health and the 404B. In this particular case, why Mr. Arbery did anything Mr. Arbery did is completely irrelevant. That's not the question. It's what the defendants did. And they knew nothing about this. They knew nothing about what was in his system. And we're going to do our 403 again, where we go down the rabbit hole with Kelly Kaufman, because she's going to take the stand. She's going to then start talking all about his medical diagnosis. She's going to talk about it. And right now, Judge, you have ruled that the medical diagnosis is, from 2018, suspect at best. She never met Mr. Arbery. She never interviewed him. And she's going to look at the 10 worst moments of his life with the 404B evidence and basically go, okay, yeah, this is him. And therefore, I conclude these things. It's under 403, very, very prejudicial, and the prejudice outweighs any probative value with the fact that I don't even know if this is consistent. Frequent use of marijuana. Whether there's the stuff in his lungs means only marijuana. And they're talking about it causing him to be aggressive, combative, and confrontational. That is for the jury to decide. This is on video, and they can determine it. Dr. Kelly Kaufman's testimony on the effects of THC on Mr. Arbery are not relevant, and for the same grounds her testimony would not be allowed for his mental health, those are the exact same grounds that this court should find it's not relevant to her to talk about THC in his system. We ask that based on 401 and 403, and for the exact same reasons the court has already found in excluding evidence of his prior acts and his mental health diagnosis, that you deny this motion. Because at this point, those two rulings will go right out the window with Dr. Kelly Kaufman taking the stand, and we're going to go through all of that evidence. And at this point in time, the state would, of course, want to put up an expert to rebut this. And we end up with our mini trial within a trial again. So we ask that you exclude the THC evidence. The state will not be putting any of that in, and will not be putting any toxicology BAC in, and will not be asking the medical examiner about those reports. Thank you, Judge.
I don't want to restate my position, Your Honor, but I would like to address the mini trial. We don't need a mini trial on this, Your Honor. The defendant needs a fair trial, though. He's entitled to that. And for her to come up and say he has a diagnosis and that THC use by a person with that diagnosis does not create a mini trial. It creates a cross-examination. The state is threatening the court with a mini trial.
I'm hearing from both sides. You're
No,
throwing out.
I'm not saying
Let me
you're.
direct you to your statement that said basically what McWilliams says. If I decide something different than what you just said, that's reversible error.
It is.
Listen, stick to your arguments.
Sure.
I'll listen to them. But let's not talk about either side threatening the court with whatever may occur. You all are advocates. Go ahead and advocate your position.
We gave the state our brief on this issue with McWilliams cited in the brief. State's had plenty of time.
All right, there are really two separate things that were just raised, one of which actually I don't think is briefed. The first is the issue that's brought up by Dr. Kelly Kaufman's potential appearance in this case. So let's address that first. Defense had filed a response to the state's motion in limine, addressing specifically the second toxicology report. Wanted to demonstrate that the presence of THC in the absence of Zyprexa, I think I'm pronouncing that correctly. You are. Talking about that. Now, that theory of admissibility derives itself from the gateway diagnosis. And there's no way to get past that, because it talks about, effectively the testimony, we talk about the combined effect of THC and Zyprexa. The gateway records have been excluded, and the court finds that the defense theories flowing from those gateways, or from the gateway diagnosis, would be inadmissible. And I've written down what Dr. Kaufman was going to testify to. That's in the record, I think was repeated accurately here. I did, in my notes, put in that, at least based on where I thought we were with this before argument, that really the thought-provoking side of this is this theory that is out there about alcohol and the lack of alcohol. What I'm hearing is that the state doesn't intend to go down that road, so that is not something the court's going to need to address, understanding that that is not an issue in the case. The other part of this, which I think I heard the defense argue, is that somehow the THC is just relevant on its own.
No.
Okay, I just want to make sure I was clear about that. I thought I heard a second argument in there.
No, it's not. It's relevant with Dr. Kaufman's findings. The gateway records, Your Honor, are documents of statements by Mr. Arbery. They're also observations made. The conclusion of his diagnosis, that may be by the RN and the PRN there at Gateway, but those records are a repository of observations and statements made by Mr. Arbery and then taken into consideration by Dr. Kaufman. The court has not allowed us to put up Dr. Kaufman yet. We have tried to summarize for the court, but we still intended to make a record through Dr. Kaufman of why she came to her independent diagnosis. So to say that you've already found that the diagnosis made by the nurse at Gateway now would preclude it, we would say to Your Honor, you need to still hear from Dr. Kaufman. She has much more education, much more information than the folks at Gateway did, and her diagnosis is firm. And so, but it would be, Your Honor, as Your Honor's pointing out, it's not just the presence of THC. It's unique to a person who's been diagnosed.
The court issued an extensive order on the mental health records, the Gateway records. And to me, this is an additional layer to that. Yeah, based on the court's prior findings and my understanding of what this particular evidence would be used for, that motion in limine is granted. You know, I may have reversed on the use of force. I think I said it was, the motion was denied. I'm reversing myself here. It's granted. It's the state's motion. So just to clarify the record on 4.68.
Is the court going to prevent us from getting into the autopsy and the findings of the autopsy and the results of the lab tests that were done? I understand the state's motion in limine is about that THC can cause aggressive behavior, et cetera. Is the court going to prevent us from asking about the full autopsy that was conducted and all the findings of the autopsy, included that toxicology was ordered, and all of that, based on what the medical examiner did?
That's why I was asking whether or not that's the second part of that argument that I thought I heard.
Yeah. No, we're not arguing that the presence of THC in of itself has a factor to aggressiveness.
Well, no, that wasn't what that the presence of THC is relevant in some way to this case. That was the second argument that I was referring to.
Yeah, I understand. I understand what you're asking. I'm just asking, are we allowed to get into all that was conducted to the autopsy, that they did a toxicology, that they sought that kind of information, or is the court going to prevent us from asking any questions about findings in the lungs or doing toxicology?
What I understand is that the level of THC in the toxicology report is, and my brain's not working right now, but it is, there's no expert, nobody that can explain what that level, what is it, 0.3 or 3 nanograms per milliliter, whatever the number is, what that means or what it is.
Except for our expert.
Okay. Your expert's going to come in, but your expert, you're saying they're coming in to testify that that amount, when combined with the lack of another drug in somebody in the mental state that she has decided forensically he was in, it has some sort of potential effect.
Yeah, the presence of THC.
That's what I've ruled on, is that's not all coming in.
I understand.
Okay. Now, the second level, which is the second argument that I was asking about really, is so the THC is out there. I understand nobody's at this point able to come in to say that that has any known effect at that level in this particular individual. Is that a fair?
Absent the connection to mental illness, right. Yeah, there's not an expert that we're going to present that would say at this level in just a typical person it could cause aggression.
So
That's correct.
what I need to think through, and I'll take under advisement, because what I understand the question really to be then is, if we go through the autopsy and the toxicology reports are out there and it shows that there's this THC, is the court not going to permit the toxicology report in that has that level? I guess that depends in part on what position anybody's taking on it.
Or the absence of medication. I mean, these are things that were investigated. There's a reason that the medical examiner's office investigated this, Your Honor. There's a reason that they wanted to understand this, but the court is going to be shutting us down because these medical. Yes, sir.
Okay, the court's ruled on the mental health side of it. From what I understand, the GBI was interested in the issue, and so they followed up. That doesn't necessarily mean that it's relevant at trial. This was the follow-up. So a second toxicology report was done, showed an absence of a particular drug, and because it was from what I understand from the briefing, a more involved, it brought up a small amount of THC. Yeah. I don't know what that small amount of THC means. So maybe before I get to the point where I make a decision about the toxicology report, someone can educate me about what, if anything, that means. And if it doesn't mean anything, and what ends up happening at trial is I end up hearing arguments to the jury, well, you know, there was this, you know, it's marijuana in the system, and, you know, it becomes an issue in the case. I've got to take all of that into consideration. That gets back into 401 and 403, which gets back to my point is, I think I did hear the second argument, which is we kind of want that THC number to be there. We want the toxicology report to come in because it's part of the autopsy.
Well, I also, we're not trying to seek evidence for inadmissible purposes, but here's one of the issues that I'm asking about now. The medical examiner has an interest in understanding what happened at the time of conflict and dives down into the body of the decedent to understand what could have led to the conflict. The court has said, I'm not letting in evidence that this young man had a mental illness or was diagnosed as such. The medical examiner was interested in that.
Well, I understand from the briefing that Richard Dahl was interested in that, and he asked for the second toxicology report. He's not the medical examiner.
No, we've talked to the medical examiner. The medical examiner has an interest in understanding whether this gentleman was on medications or not.
Stop for a second. I'm not going to go further down here.
Okay.
The medical examiner in the original autopsy didn't do this. He was asked for the second toxicology report. He could have,
Yeah.
and if he's not the individual that requested it, he didn't. There's now the
I'm
report.
talking about Zyprexa as well. He asked for
Stop for a second.
Zyprexa.
I've already ruled upon the first part of this.
Okay.
That's not coming in.
So I
The
guess what we
second
would
part,
need to do, I'm sorry. I understand the court's ruling.
I've already said, the second part of it is, apparently, we're going to run into some debate about this toxicology report.
Right.
I guess the first thing to do is let's talk about it, because I don't even know if it's coming in. I don't know who's going to get it in. And then if there's an issue there, I'll see if I can address it.
Okay.
But this is a motion in limine. The motion in limine was specifically related, as I understood,
Right.
to this expert's opinion that touches upon some of these gateway records. I've ruled on that. That motion was granted.
I understand that very clearly. So my point of inquiry was whether we'll be allowed to dive deeper into the autopsy and things that the medical examiner was interested in, like the gateway records, like the Zyprexa or absence of medication for the diagnosis. Those things, if, and the court is essentially saying, no, we're not going to let you talk with the medical examiner in front of the jury about the medical examiner's interest in understanding those issues for the purpose of trying to make a conclusion during the course of the autopsy, then we just would need to make a record of that with the medical examiner. And perhaps it'll become more relevant at that time and the court would change its mind on prior rulings. But I think I understand you're going to prevent us from going into toxicology. You're going to prevent us from talking about corroboration of THC use, excessive THC, unless perhaps we can come back and educate the court on THC use in of itself causing aggressive behavior, confrontational behavior, outside and isolated from mental illness diagnosis.
I've
That was
ruled.
my question to the court, and I think we've
The
worked
court's
through that.
ruled. The court granted the motion in limine. So
Well,
at
that
this,
was for that one issue, but we're also talking about other things that were done, so I thought I'd bring it up.
I would caution counsel, the court has ruled, made very clear in a very long order,
Right.
looking at 401 and 403, other relevant statutes and case law, where the court is on the gateway records and the mental health diagnosis. I would suggest that's a starting point to educate counsel on where the court is on those records. I've also now ruled that this other way of getting to the records, which is through the testimony of a lack of substance and presence of a small amount of THC, that's out. That's not another way that the defense is going to use to get to the gateway records. The court has an extensive order on the matter.
I know. It's just a separate issue. It's not another way to get to backdoor. This is a separate issue dealing with aggression and primary aggression. That's all we're trying to make a record of, Your Honor. I understand the court's order.
let's go ahead. Let's just go ahead and take a 10-minute recess. The next matter I have is 4.71, this motion eliminated from the state regarding probation. Probation.